What are the components of what you characterize as a ghost gun?
Look, the core of the ghost gun is the frame or the receiver that can be readily converted into operational status. And ATF is making
So hold on a second. Let's be clear. The frame or the receiver, or the frame and the receiver? What is it?
It's a good question, sir, but the frame
I know it is
for the handgun and the receiver is for the long gun.
When you personally assisted with a hand drill, not even an electric, you're talking a hand drill with a crank, right? When you assisted with that, at what point did those components become a gun?
When Polymer 80 was selling those parts, those are firearms and should be regulated as such.
At what point did it, so when it was in the package and it showed up, was it a gun?
Yes, that's a firearm.
You could fire it. You could fire it when it showed up in the package.
That's not what the law says, sir.
No, I'm asking you. When it showed up, however it showed up at the house, in the package, before the drill, the hand drill, and the file, was it a gun?
Yes, sir, because Congress has defined firearms.
Could you fire it?
That's not how Congress defined firearms, sir.
And how does Congress define firearm?
An operational weapon?
Is it operational when it shows up in the mail, the components?
Yes, sir.
So why are you filing and why are you drilling it?
Because the firearm definition is operational.
No, I'm asking you, if it doesn't work when it shows up, why do you have to do those things? Sir, the point is it's not a gun. And by the way, you have no idea what you're talking about regarding receivers or frames.
Biden's anti-gun crusade takes another defeat, a win for gun owners. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC, P.A.N. Firearms for NRS certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like my channel, like my content, and what I do here, you can support me with the link in the description box. Everything is appreciated. And let's talk about this. Now, a judge in Texas, Reed O'Connor, has struck down the ATF's rule on unfinished frames and receivers, or 80% parts. And this is a massive win for gun owners. The judge, to just basically encapsulate what he is saying here, is saying that the ATF has overstepped its boundaries, going from a regulatory agency to a lawmaking agency, which they do not have the authority to do. And this is the crutch behind the argument against the arm brace rule, obviously the 80% receiver rule, and the bump stock ban. This has been the crutch of the argument. The ATF has overstepped its boundaries. I want to jump in right here. Bearing arms, huge win for gun owners as federal judge vacates ATF rule on unfinished frames and receivers. Joe Biden's anti-gun agenda has taken another body blow, with a U.S. district judge in Texas putting a halt to the ATF's rule treating unfinished frames and receivers as if they're firearms themselves. Now, he has put a halt on it, but if your state has, such as Connecticut, has a law that says you can't have these items, we're still under that law. So don't jump up and down here in Connecticut yet. I mean, it's a few other states. Don't get too excited, but this is a step in the right direction. In a Friday decision, Judge Reed O'Connor smacked down the rule, finding that the ATF overstepped its authority to promulgate regulations and instead crossed the line into making new law. The Firearm Policy Coalition, which sued the agency along with the Second Amendment Foundation and several individual plaintiffs, celebrated with a late-night email to members and supporters. Quote, "We're thrilled to see the court agree with the ATF's frame or receiver rule exceeds the agency's congressionally limited authority," said Cody J. Wisniewski, FPCAF's senior attorney for constitutional litigation and FPC's counsel in this case. With this decision, the court has probably struck down the ATF's rule and ensured that it cannot enforce that which it never had the authority to publish in the first place. And that is literally the foundation of every argument that's come forward, that with these rules that the ATF has been putting out. The ATF does not have the authority to do this. This is a monumental victory against the tyrannical ATF, Firearms Policy Coalition, FPC law, have argued that this rogue agency has unlawfully attacked gun owners in this latest round of rulemaking, and we're grateful to see the court agree, said Richard Thompson, FPC's Vice President of Communications. We will not stop, however, with this latest victory. FPC and FPC law will continue to bring these cases to put a stop to the immoral and unconstitutional actions of the disarmament regime. Now, I'm going to come down to here. So what happens next? DOJ will most certainly appeal O'Connor's decision to the Fifth Circuit because they spend our money to defend themselves. That's why they have no problem wasting our money to defend an unconstitutional law. It's not their money, it's our money. Which has already taken a dim view of the ATF's ban on bump stocks and its rule on pistol braces. I'd be shocked to see the appeals court reverse O'Connor's ruling or even stay the order while the case is on appeal. But that request is still likely to come next week. In the meantime, enjoy kicking off your Independence Day weekend with a little more freedom than you had Friday morning, and raise a glass to the Second Amendment advocates who kicked the Biden administration's rear end in court. As well as toast to Judge O'Connor for seeing the ATF rule for what it is, an unlawful abuse of the agency's authority. Now, I'm going to jump into the judge's ruling because there's a section here that I definitely want to go into, and this is on it, and I'll put the link to the his ruling so you can go get in there and see this. But this is on page 25. It's titled "I Parts that may become receivers are not receivers." This is the judge's ruling. Congress carefully defined its term in the Gun Control Act. The primary definition of firearm in the CGA or GCA contains three parts. Any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Under this primary definition, a firearm is first and foremost a weapon. Underscoring that point, Congress explicitly named starter guns in the definition because starter guns are not obviously weapons. Then, because weapon parts also are not weapons, Congress created a secondary definition covering specific weapon parts, the frame or receiver of any such weapon. Notably, Congress did not cover all weapons parts, only frames and receivers, and only the frames and receivers of any such weapon that Congress described in its primary definition. Because Congress did not define frame or receiver, the words received their ordinary meanings. And he gives a reference. Contrary to defendant's assertion, in an interpretive dispute over statutory terms, meaning the court does not simply leave the precise definition of that term to the discretion and expertise of the ATF, nor is the court bound by the agency's definition of an unambiguous statutory term, even if the ATF has long provided regulations defining frame or receiver. Plaintiffs do not take issue with ATF's 1978 definition of frame or receiver. This is because, as defendant themselves acknowledge, ATF's prior regulatory definitions have been consistent with common and technical dictionary definitions. Statutory construction entails following the plain and unambiguous meaning of the statutory language and interpreting undefined terms according to their ordinary and natural meaning and the overall policies and objectives of the statute. Now it goes on from there, but that right there is very, very powerful language he's putting out there. But I'm going to come to this because this is another very important part. Near the time of GCA's enactment in 1968, Webster's dictionary defined frame as the basic unit of a handgun, which serves as the mounting for the barrel and operating parts of the arm and receiver, as the metal frame in which the action of a firearm is fitted and which the breech end of the barrel is attached. He mentions the definition and the addition of the Webster dictionary. ATF's prior regulatory definition would define frame or receiver as that part of a firearm which provides housing for the hammer, bolt, or breech block and firing mechanism, and which is usually threaded at its forward position to receive a barrel track. That common definition, title and definition, changes. But the final rule's amended definition of frame receiver does not accord with the ordinary meaning of those terms and is therefore in conflict with the plain statutory language. And it goes on from there. He really breaks it down. So here's how it plays out. At the bottom line, to make it either layman's terms, the judge is saying the ATF, you just literally went against your own definition. You went against your regulatory position to become a lawmaking position. And that's not going to fly with me. That's why he knocked it down. This is huge news because this is, once again, is leading the snowball coming down the mountain to the arm brace rule and also to the bump stock ban. It's all going to fall under that ideal. The ATF cannot make law, and this judge just pretty much laid it down there with the gavel. But great news. Let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.